online educational luncheon will be recorded. So I do ask you that if you are not presenting or asking a question at the end of today's presentation, just to make sure that you keep your microphone muted. That way our presenter today can get through their presentation uninterrupted. So please check and make sure that your microphone is muted on your end if you are not one of the presenters. Good afternoon to everyone. My name is Fred Steinman. I am the director for the Northern Section of the Nevada Chapter of the American Planning Association. And it's my pleasure to welcome all of you today to this online educational luncheon featuring Mr. Steven Silva, an attorney here in Reno with Blanchard, Krasner, and French, who will be giving us a repeat, do-over, another version of the planning and law presentation that Mr. Silva was able to present at the chapter's annual conference back in October of this year. Before I formally introduce Mr. Silva, just a few quick announcements. We are, of course, as the Northern Section, resuming our online educational luncheon series. We, of course, took a pause in advance of the Nevada APA annual conference, again, that was held back in early October, and then just kind of sorting out all the post-conference business. But again, we're very pleased to have Mr. Silva restart our online educational luncheons. As a further reminder, in partnership with the College of Business at the University of Nevada, Reno, the Northern Section of the Nevada Chapter of the American Planning Association is proud to partner with them to deliver and develop a new speaker series. It'll be an online educational luncheon series beginning next Tuesday, November 10th. With the College of Business, we'll be exploring various racial and social inequality issues in business and planning and city and county administration. Our first presenter, as part of this ongoing speaker series that will begin in November, end in February of 2021, will feature Mr. Kenneth Evans, who is the current president of the Urban Chamber of Commerce in Las Vegas, Nevada. Of course, I'll make sure that you get the flyer for this event. All the online educational luncheons that the Northern Section hosts are free. And of course, all these coming speaker series educational luncheons will be free as well. We're very happy to have Mr. Evans join us and lead off that speaker series, and the chapter in the Northern Section in particular is very happy to partner with the College of Business as well as the Lead Business School at the University of Nevada, Las Vegas to develop and deliver this series. But certainly, again, I will get all that information out to you. So without any further ado, it is again my pleasure and with the most sincerest thanks from the Nevada Chapter of the American Planning Association to Mr. Silva for his years of support of the chapter and the chapter's efforts to introduce him. As I've already indicated, Mr. Silva is an attorney with Blanchard, Krasner, and French here in Reno. He's an attorney focusing on real property and government matters, primarily representing public entities. Mr. Silva frequently writes and presents in the areas of law and ethics for lawyers, surveyors, planners, and other land use and property professionals. And he is also a fellow member, faculty member of the Nevada System of Higher Education, as he also teaches real property law at Truckee Meadows Community College. So without any further ado, Mr. Silva, thank you very much for being with us today, and the floor is yours.
Well, thank you very much for the very kind and generous introduction. My name is Steve Silva. I'm a partner with Blanchard, Krasner, and French. I see a couple of city names popping up in the attendee list. Some I know, some I don't, which is always nice to make new friends. We're going to chat today about three basic things. First, we're going to go over a very quick legal update on the recent case laws in eminent domain as it relates to primarily land use, but also some broader eminent domain cases that have land use and planning implications. We're then going to talk about some Nevada-specific issues in planning, specifically something called precondemnation damages. that is unique to Nevada and has a little bleed over in California. So that should be of interest to some of you. And then we're going to talk about general ethics. The American Planning Association has a specific format for providing you with ethics training. So we're going to stick to those requirements. Bear with me for a few seconds because I've got a lovely PowerPoint presentation to share with you, but I'm actually not the most tech savvy guy. So bear with me.
While Steve is pulling up his presentation, just as a reminder to everyone, I forgot to mention this, this session is worth 1.5 AICP CM credits for both planning law and ethics. So if you are attending to check your planning law and planning ethics AICP CM credits, this session satisfies both of that. Sorry, Steve, go ahead.
Oh, no, not a problem at all. All right. Can somebody verify that you are seeing a screen that says planning, police powers, and going too far?
It's up.
All right. Let us dive into it. I want you guys to begin by understanding that almost all land use issues are governed ostensibly by what we call the police power. And we're going to talk a little bit more about that throughout this slideshow. But I want you to understand before we even get into things that if you, quote, go too far, and that is the legal term of art, in your use of police power, that action can fall outside of the power, and then it will be held to be governed by some of the other great powers of state. Typically, and in my line of work, that goes from the police power to the power of eminent domain. Now, the eminent domain cases are directly applicable through direct condemnation. And the cities and counties and states are pretty good about doing that. Every state in our nation has a code that tells you how you exercise eminent domain when you want to. But what happens if you have accidentally eminent domained something without intending to? And how do you know when you're there? That can be unclear. Fortunately, in Nevada, we have some clarity here on when you may have inversely condemned something. That means that the government's actions as it relates to land are outside of the police power and have resulted in a, quote, taking. That is the term in our Constitution is, quote, taking. And so how do you know when you're there? Well, the Nevada Supreme Court gave us some clarity, finally, in a case called Fritz versus Washoe County. The case proceeded basically as follows. A guy lives at the bottom of the hill, and there is uphill development that is approved, and perhaps with an agreement between the county and NDOT to preferentially channel water away from Mount Rose Highway and down a historic creek, which seems perfectly sensible. But the landowner alleged that that basically volunteered and sacrificed his property for flood water storage. The landowners were unsuccessful at the trial court. The matter was dismissed on summary judgment. The landowners took it up on appeal to the Nevada Supreme Court, and they were successful in having the matter reversed at the Nevada Supreme Court. Now, this is back in 2016, and I have given a presentation on this case a couple times, so I won't bore you with the nitty-gritty details. But I want you to know that on remand, and this did happen recently, the Fritzes went to a trial. And the trial was held in front of a judge. It was not a jury trial. And the landowners lost. They were not able to actually show that anything that the government did had actually taken their property. There was a finding of no liability. Of interest, on the second appeal, the matter goes back up to the Nevada Supreme Court, the landowners raised the issue of whether or not they should have been entitled to a jury trial on the liability determination. And the answer to that question is no. Issues of liability in eminent domain are to be resolved by the bench. Landowners didn't like the answer, so they kept asking for the Nevada Supreme Court to take a second look at it with rehearing and en banc reconsideration. They lost each time. They filed a petition for a writ of certiorari with the United States Supreme Court, and they were denied there as well. So for anyone who is up to date on Fritz versus Washoe back from 2016, I want you to know that the matter has been fully resolved, and of some interest, the power of the courts to adjudicate whether there has been a taking was upheld. This is an important issue because if the question of whether or not there has been a taking on a flooding case is something that would go to a jury, the same rule would hold as to whether or not regulation of land under the police power had, quote, gone too far and thus resulted in a taking. And if that is to be decided by a jury, you run a very significant risk that sympathetic fact patterns might drive determinations of taking where none is appropriate. So this is a good result, generally speaking, for the government as a practical matter, because it reduces the likelihood of rogue jury findings of liability. But frankly, it's a good result for everyone interested in the orderly administration of justice. All right, next big thing to let you know about in the area of eminent domain and land use regulation litigation is that the doors of the federal courts are open. For the past 30 years, the rule had been that if you wanted to sue for inverse condemnation, which is the cause of action that lets you challenge overly burdensome land use regulation, you had to go to state court. You couldn't go to federal district court. And that has changed. The landowners are now able to bring what we call 42 USC 1983 actions against local governments directly in federal district court. Probably not of particular interest directly to planners, except that for any of you who testify regularly in state court as expert witnesses, you will need to understand the rules in federal district court. And the expert witness rules, for any of you who serve as expert witness, are different between state and federal court. Certainly any attorneys that you are working with you on those should be able to assist you with it, but you may need to take a look at your report forms and make sure that you are compliant with whichever court you are in. One last thing to note is that some municipalities, by which I mean City of Las Vegas, has tried to use the NIC decision to remove state court cases to federal court for reasons unknown to me. They were unsuccessful. This does appear to be a landowner's election in terms of where to bring their case. I will also note that it does not directly implicate claims against the state itself, at least not yet. All right. Let's focus in a little bit on Nevada, and let's focus in a little bit on planning. I've got some good news. Planning is good. I've got some bad news. The courts do not understand planning. If you read the recent decisions from the Nevada Supreme Court in particular, you will read very closely that the courts seem to think of planning as a distinct thing that happens once. And then after the plan for a thing exists, now we go into an action phase. And this ignores the plan that planning is ongoing. And that as soon as a plan is adopted, we cycle right in from our Reno 2020 vision to our 2040. And our 2060, I think, is already underway because that's how planning actually works, and courts do not understand this reality. The difficulty becomes this. If you are engaged in the planning process and at the same time, a government is engaged in project development consistent with the plan. And specifically here, I'm talking primarily about roadway planning, not so much zoning or development oriented planning, but the rules apply for both. if you have a situation where you are engaged in planning and project actualization, the court seems to think that you have left the planning stage and entered for roadways an acquisition phase. For other projects, the rule seems to be that it is a project actualization phase. And this can open the door to liability for the government. The classic example is supposed to work like this. After planning a project, after deciding, how it's going to regulate land, and after deciding what lands it needs for a roadway project, the city announces its intent to condemn certain property. And then either doesn't or begins to act like a bully in a way that drives down value. Those are the classic harms that the cause of action that we like to call precondemnation damages is designed to avoid. The recent trend, however, based on the court's failure to understand the planning process, is that any actions that are tantamount to a formal condemnation action announcement will be sufficient to, quote, announce intent to condemn, end quote. And as applied, it seems that even merely publicizing a project that, will likely or inevitably lead to an acquisition can put you into a category where the court will think that you have left planning and entered acquisition. A couple of examples from cases of where you will have left planning and gone into an acquisition phase is where a condemning authority denied landowner access to property as part of construction, or where the condemning authority's inadequate offer of compensation coupled with the possibility of levying an assessment for a project was held to be the sort of bullying conduct that the court wanted to dissuade. Likewise, where a landowner lost rental income during a delay of an acquisition based on extensive publicity of project. And I'll give you a note on number 3. That is what the court found happened. I don't necessarily know if that's the truth of the matter, but the court was persuaded that it was the publicity of the project that caused loss of rental income. And finally, where a condemning agency acted deliberately to reduce value of property by denying permits and reducing services. This last one is not really a problem in Nevada. Most of our government entities are actually quite good at making sure that they are treating landowners carefully. This is a Michigan case that was pretty brutal, although I will say that in the past in Nevada, the use of government power to regulate land in a way that was designed to reduce value so that a subsequent acquisition would be cheaper actually did happen back in the 1970s. The city of Las Vegas denied improvement to a recording studio specifically so that NDOT could acquire it at a cheaper price. So when you are engaged in planning decisions or recommendations, you need to make sure that you understand that when you're recommending a regulation of land, specifically that can affect its value, an up zone, a down zone, special use permit, conditional use permit, things of these natures, you need to understand what other things might be happening to affect the property. Because the last thing you want is for it to be held that your decision or your recommendation not to approve some sort of upzoning that would enhance the value of a property was done for the purpose of devaluing the property, such that instead of just regulating land, you are held to have either taken it or to have engaged in some sort of precondemnation damage. So my practical recommendation for you on this, as well as an ethical imperative, is when you are engaged in a limited planning project, make sure you understand the context, where the land is in relation to other things. So you make sure you're not stepping on anybody else's toes. I want to talk to you guys a little bit as background about dedications and exactions. And I'm going to zip through this pretty quickly because most of you should be pretty savvy on these. Dedications and exactions come from the police power. The government has several intersecting great powers of state. And right here, we're focused primarily on police power and power of eminent domain. And I want to reiterate that if you go too far, which is the term of art, that is what the US Supreme Court said, is if police power, quote, goes too far, it can be a taking. To illustrate how some of these intersecting things can come into play. We in this state have a fantastic example in the Sisolak versus McCarran airport case. The county banned development of certain lands over 150 feet. This is fine. You can have a municipal code, a ordinance, design standards, development standards that limit height of buildings. And you can do so without having to pay just compensation, because the regulation of land can include the regulation of height. But the county had banned this development because it wanted to allow air flights over the land between 150 to 500 feet. The holding in this case is that this was a taking. It invoked the power of eminent domain. The important thing to keep in mind is that the same height limitation likely could have been placed just through zoning under the police power with no compensation. But because it was done for the express purpose of allowing public use of the airspace, it changed which power was implicated. Sisolak is a great example because it can lead to weaker cases where there is an allegation that the land use regulation was for some impermissible purpose. Now in Sisolak, as it turned out, that regulation really was to allow trespassing into property owned by private owners. And so the holding in Sisolak, I think, is quite good. But it can lead you into a situation where it can be harder to tell. And this is because, and I got some real bad news for you here, there is no single precise rule to determine whether a dedication or exaction meets constitutional muster. The courts use what we call an ad hoc analysis. And it is simply when it, quote, goes too far. And this goes too far analysis is creeping into planning. The classic goes too far cases are Nolan and Dolan, which I believe most of you have read as part of your planning education. But just to recap, Nolan is what we call a law by syllogism. If X is okay and Y is like X, then Y ought to be okay. For example, the public interest can be served by banning development. That's fine. And that's not going to be a taking. You can ban development. You can say, no, you can't have your apartment complex there. And that's within the power of the government. So something less than a total ban, if it is for the same purpose, if it's based on the same rationale, should also be okay. But the issue becomes whether or not the condition, the lesser government interference, is for the same legitimate government purpose that would support a denial. Here, what we're getting at is the notion that, and it was criticized within the opinion. I've got in the slideshow, which I think will be made available to you, some text, some criticism that it can be very difficult to apply, but the basic takeaway is, if you could say, no, you can't build here because it's going to create too much traffic, then you're pretty good to say, we will only let you build here if you widen the road for us at your expense. That's going to be fine. But you can't say, hey, we're going to deny your permit here because you're going to improve too much traffic, but build us a lovely park on the other side of town and we'll let you slide. The US Supreme Court held that that would be tantamount to extortion. The problem is, I've given you two examples, one that's clearly good, one that's clearly not good. Where is the line? And the court could not articulate a bright line definition. And so in Justice Stevens's dissent in Nolan, it said point blank, even the wisest lawyers would have to acknowledge great uncertainty about the scope of the court taking jurisprudence. And as a result, local governments and officials must pay the price for the necessarily vague standards in this area of law. An expression of sympathy that, frankly, there's no way to do this with mathematic precision. And unfortunately, that means that the government is stuck with those costs. The next classic case is Dolan, which enhanced the idea of Nolan, and it is fun that they rhyme because it makes it easy to remember, from one of a nexus, that is, that you have to only impose restrictions and conditions that are consistent with denial, to the scope. So, for example, we'll go back to this. We've got a traffic issue. You've got this nexus where increased traffic will result in road improvements, but how far can you go? If a development is going to add 2,000 daily trips of traffic, are you going to get a freeway out of that? No. If development's going to add 2,000 new students, do you get 30 schools? So you can have lots of little tiny schools in there? Probably not. When you put the two together, the rule out of Nolan and Dolan is, I think, best extracted as required reasonable relationship. Now, this is me editorializing. If you go and talk to another attorney and you use this, they might not understand what you're talking about. What they will understand is that you have to have a nexus to the proposed development. That is, that the condition has to have some logical connection, some necessary logical connection to the proposed development, and it must be roughly proportional. I think that you put those two together and you've got a required reasonable relationship between any condition and any harm caused by the development that you are seeking to ameliorate. This is essentially a balancing test. I think it is actually quite lovely because it is philosophically similar to the notion of just compensation. In just compensation, the government gives to the landowner the amount of money needed to offset the imposition of the government's taking. In a Nolan and Dolan sort of regulation, the landowner pays money, either money or in kind, to offset the imposition on the public, but no way to get more. Based on the proportionality test, you are not supposed to get freebies for the government. This line of thought has been enhanced over the past couple of years. There's a case recently called Koontz that applies this to money exactions. Koontz, though, is a little interesting because Koontz did not result from a final imposition. If you try to exact too much but never actually impose the condition, it might still lead to a lawsuit. The basic facts, which I think are worth focusing on, are that a developer in Florida faced denial of a land use permit unless he funded off-site mitigation projects for some wetland loss. You're going to develop in wetlands, you're losing wetlands. Is there a nexus between wetland protection to loss of wetlands? Yes, absolutely. So we're focused on proportionality here. The Florida developer offered to deed 3/4 of the property as a conservation easement. This seems pretty generous and proportional. Florida wanted more. They either wanted to have the developer reduce the size of the development and fully deed the rest over. So basically the developer's offer just bigger and more intense, or hire contractors to make improvements to district property miles away. This is, I think, where they got into trouble. As the Supreme Court said, extortionate demands for property and land use permitting contexts run afoul of the takings clause. But here's where it gets weird. Run afoul of the takings clause not because they take property, but because they impermissibly burden the right not to have property taken without just compensation. That's weird, and we'll come back to that in a second. The second part of it, of Koontz, is a little interesting because it modifies, I think, Nolan and Dolan, stating, even if the respondent would have been entirely within its rights in denying the permit for some other reason, the greater authority does not imply a lesser power to condition permit approval on petitioner's forfeiture of the petitioner's constitutional rights. Here, I think the difficulty was the nexus between the improving property some other place in exchange for the permit failed the nexus test. but it really expands the protective aspects of Nolan and Dolan, and I think slightly unbalances Nolan and Dolan and tilts it in favor of landowners. The part that really confuses me here, the what in this, is that the court basically says, hey, you can have a takings clause violation even if you don't take property. The mere threat of taking property or the mere imposition of a condition that might be a taking if it were fully actualized can be sufficient to damage somebody, sufficient to bring a suit. This is very similar, I think, to the logical underpinnings of our pre-condemnation damages cause of action. So I want you to just remember very quickly that Koontz says that there might be a takings clause problem even if there is no taking. That is important. By the way, these cases have ramped up since 2005, and the reason for that is because in 2005, the U.S. Supreme Court decided a case called Lingle that really refined some of its prior jurisprudence in ways that I agree with, frankly, but it does widen the scope of what can be sued over. Previously, there had been a notion that if something substantially advanced the public interest, that could be a legal defense for a regulation to support it against a takings clause. Court changed their mind and concluded that substantially advancing a public interest is a valid rule for due process claims, but doesn't necessarily provide a defense for just compensation. Essentially, if something validly, substantially advances a public interest, that might give a city a reason to get something out of the landowner, but that does not mean that you can do it for free. So for anybody who's been in planning for a long time and who's been working on conditions for a long time, and who has just reflexively been using the substantially advanced public interest test for dedications in particular, please keep in mind that that has changed recently, although I guess in 2005 that's not so recent anymore. But it is now becoming the subject of more and more litigation, that what would have been seen as routine dedication requests are now becoming a little more contested. Sisolak we discussed previously. I have some more detail on it in the slideshow for anybody who wants to peruse. I do want to note that there is one troubling thing in Sisolak, something that I hope never actually comes up. The court in Sisolak has some language that I've underlined here saying, quote, requiring an uncompensated easement as condition to development is improper and cannot be used by the county as a defense to the taking of a landowner's airspace without compensation. And further, to obtain easements of access across private property, the state must proceed through its eminent domain power, because requiring an uncompensated conveyance of an easement outright would violate the 14th Amendment. If you take those two sentences quite literally, it might imply that the court thinks that easements always need to be compensated and maybe cannot be traded away, quote, for free for what is actually an in-kind development approval. I hope that the court does not mean that as maximally as those sentences taken out of context can be. But I do want to make sure that when people are focusing on access easements in particular, or right-of-way dedications, that you keep in the back of your mind that the courts are growing increasingly suspicious of these. I will note that the uncompensated easement language justifies itself by citing to Nolan, and Nolan really only goes so far as to say that an uncompensated conveyance would be a problem when it wasn't attached to a development plan or when there's no nexus. So I think as long as you're within the Nolan nexus test, you should be fine. But keep in mind that our Nevada Supreme Court has language that does go farther than that. Taking all of these together has some pragmatic rules when you're looking at large public projects or when you're looking at regulation and proposals for conditions of private projects. We've got a couple of rules of thumb here. Number one, exactions and dedications without compensation requests seem to only be legitimate when the developer comes to the city for some permit. So if you've got a roadway project and you want to go get the right of way for it, and there's nothing pending in front of the city that would impact roadways, you're going to need to go through the power of eminent domain. You're going to need to condemn or buy those interests if challenged. I think you can ask for a dedication, but if the landowner says no, I think you're kind of done and dusted at that point. The requests have to be particularized to the development and can only go to mitigate the impact of the development. And it has to be focused on the needs of the development, not the needs of the general public. And I want you to understand that on those points, Nevada law is more protective than federal law. To extract those in kind of plain language, don't make your problem other people's problems. If the public has a problem, the public needs to solve it. You can't solve public problems with individual other people's property. The North Star of eminent domain jurisprudence is that one person alone should not bear burdens that in all fairness should be borne by the public. If a dedication would be good for the public, that certainly justifies the city or county demanding it. But unless it meets the Nolan and Dolan test, it's going to be compensable. It's not going to be a problem that you can have the private citizen solve for you. Now, that's not too bleak, because if private citizenry is causing the problem, you can force them to solve the problem that they are causing. So we've got a couple of recommendations to stop doing some things. I highly recommend the Seagulls Stop It Now video if you have not seen it. Given our time constraints, I will not play it for you, but it's quite funny. All right, stop exacting lands and money for nothing. If the city wants to widen a road and the developer owns an undeveloped piece of land adjacent to the road, can you ask for a free dedication of land? Based on these facts, no, you can't. I mean, you could probably ask, but if the landowner won't do it, you gotta stop. Scenario B, the city intends to widen a road. The developer comes in to obtain a parcel map subdividing 18 acres into 4 lots. The city asks for free dedication and for the developer to participate in offsite improvements. And for this hypothetical, we're going to assume that construction and dedication, or money in lieu in terms of participating in the offsite improvements, are the same. Does this meet Nolan and Dolan? And again, on these facts, probably no. The developer is asking for something that intensifies the use of the land, which would probably warrant some dedications. But for a mere parcel map, the offsites are going to be difficult to support here. Finally, scenario C, the city has no particular plan. A developer comes in for a lot line adjustment and the city will approve in exchange for $1 billion. And if you were seeing me on video right now, you would see me doing the Dr. Evil pinky to lip thing. Just imagine that in your mind, and this presentation is funnier. Don't do that. That is extortion. The courts are suspicious enough of government acquisitions of property for developments as being extortionate. Don't prove them right. All right. Scenario D. A developer comes into the city to turn vacant land into a multi-tenant shopping center complex in Ward 1. Let's just say Ward 1 here in Reno. The city requests a free park in Ward 3. This is going to be a problem because it doesn't seem like there's a connection between intensifying use in Ward 1 with needing free stuff over in Ward 3. All right, let's go back. Let's go further. A developer comes into the city seeking again to put a multifamily complex, 200 units on 1.59 acres vacant lot that currently has unsignalized intersections on every corner of the parcel. And this is going to require a zone change. The development's going to add 1,400 trips per day, and the city asks the developer to construct the road and signalize the intersections, which are shockingly expensive, those lights. This one actually seems solid because it's going to be based on the warrants analysis of MUTCD 4C. because you've got some rational thing to point it to, and because the harms that you are seeking to cure are only those harms caused by the proposed development, I think you are in the clear on this one. All right. The government's suspicion not the government's, I apologize, the court's suspicion of government conduct, as exemplified by Koontz, goes to planning nowadays. In Nevada in particular, we have what we call a cause of action for precondemnation damages, which is very simply when the court thinks planning has gone too far. This is an issue that is currently being heavily litigated. There's only been one really bad case for the government, which was the 5th and Centennial case. It's a road widening project out of North Las Vegas, but it was pretty scary. The reason why is this. We have to not only plan, but we also have to plan pursuant to codes and statutes. Planning isn't just some sort of ad hoc thing that you sit down and you just draw things that look cute. And as the city of North Las Vegas was complying with its mandates to engage in roadway planning, the following problems happened. The court concluded that the activities of the city had exceeded the traditional bounds of planning and had entered into what it defined as the acquiring phase, which is that a public project's planning officially announced the intent to condemn the property at issue in that case and took steps towards a filing in a formal eminent domain action or otherwise impacted the property. So what happened here? It's a little hard to say with 100% certainty because the Nevada Supreme Court's order in this case, finding liability, was originally unpublished. And so it was not written with the care and precision that you would find in a published opinion. As a side digression, just so that you lay folk understand, an appeals court, including the Nevada Supreme Court, can do one of two things with a case. They can just dispose of it with an order that is designed only to answer the questions to the parties, or they can publish opinions of law that are meant to be understood by other people. Since 2016, lawyers are able to cite to unpublished orders, but they're not really written to a broader audience. So an unpublished order, which 5th and Centennial was, is not always as reliable as you would hope, and often leaves facts unstated that would be understandable by the parties, but not understandable by the broader public. So what went wrong here? Well, the court had a list of about 11 different things that the city did, and after kind of analyzing them all, the court found that the city had exceeded planning and had gone into the acquisition phase. But the critical problem seems to be that there was an imposition of a future right-of-way dedication, that is, pursuant to public plans, development would require right-of-way dedication, and it was paired with present action to preserve the land, with no formal condemnation action to presently acquire the current land. Now, some of you might already be thinking that why would there be current action to acquire any particular piece of property when there was only a future intention to acquire the property? And that really is the problem here. What the court concluded was that the city undertook, adopted, and actually implemented a 7-mile long limited access project. It was a super arterial road on North 5th Street. And that this official action went beyond mere planning and thus established the first prong of the precondemnation damage claim. The record reflects that the city took official action amounting to announcement of intent to condemn, and that following such action engaged in improper conduct. Here, the improper conduct was alleged to be delay. So what was it that the city did? Well, the court summarizes the announcement. The city's 2004 amendment to its master plan of streets and highways allowed for North Fifth Street to be widened up to 150 feet and provided that approval of development applications must be conditioned upon landowners giving up a 75-foot right-of-way on the land fronting that street. That seems to imply that amending a map was the thing that was problematic. And again, if you take the court specifically at its words, this is a problem because maps are a great planning tool, but if now they are going to give rise to this argument that as soon as you draw a line on a map, you have to acquire the right-of-way that you say you want to acquire in the future, this is a problem. Further in the case, the court does explain that the city had been acquiring some of the lands at the same time, contemporaneously with its planning, and yet failed to move forward to acquire this particular thing. To summarize in just kind of lay speak, 7 miles, you got a bunch of parcels. You draw a line asking for 75 feet along the entire 7-mile stretch. And as people come up for development, you acquire them one by one. This is how it's always been done. The court seemed to get a little bent out of shape that the city didn't acquire all 7 miles at once. Again, roping back into this notion that the court seems to view kind of these publicly planned projects as a thing that gets planned, and then once you're done, you're ready to roll on the full thing. The landowners had demonstrated that they were, quote, treated differently by paying some, the city had paid some people just compensation while forcing others with undeveloped property to dedicate the increased right-of-way as a condition of development. This, I think, goes back to the broader notion that if you are asking for the same dedication, especially for right-of-way, on any development proposal, you might put yourself in a bad situation, not just with that particular development, because it might exceed Nolan and Dolan, but that if you are engaging in these sort of exactions and dedication requirements, you may, if you are in a project, you may be starting to ring bells on other parcels of land. Conceptually, it seems that the courts are advancing these, quote, goes too far analyses on every area where government action touches development. The good news is there's no categorical bans. They're not saying you can't do these things, but they are saying you might have to pay for them more than you had in the past. As I like to say, the best laid plans, this was a good plan for a while, off go agley. If we go back to this map, if you want to go from Dusseldorf to Lille, the question is going by Brussels an efficient route? Yes, it is. Well, should you go there? Well, you know, in the 1900s, the answer was no, you shouldn't take that shortcut, because even though it's more expensive and takes longer to go via Verdun, you're not going to get dreadnoughted. The point I'm trying to make here, with a little bit of a silly analogy, is the most efficient route that had worked for years in the past might not be the best route, all things considered, at this point because of the change in law. And that's because law is a real problem. I'm sorry. The law is a problem because the law can be uncertain. And this is especially true in the areas of constitutional protections of property. Constitutional law is governed almost exclusively by case law. Very few statutes are on point because the Constitution supersedes statutes where they conflict. And this means that the law can be uncertain because this case law in our state is made by a handful of people, 7 people in Carson City, a handful of people in the Ninth Circuit in San Francisco, and then 9 people in Washington, D.C. That's it. Those are our bosses. Those are the people who tell us when something has, quote, gone too far. And the other problem with advising you all on some of these questions is it takes years to get answered. It can take a decade to get a case from, you have a problem with the developer, you have a problem with the government asking too much of your developer client, to getting something out of the US Supreme Court. It can take a decade. There's also a problem because not all fact patterns are squarely addressed by the cases. Generally, we apply analogical thinking here, which is if something is close, it's probably going to be governed by the same rule. But that's not always true. And sometimes it can be hard to tell which factors will persuade the court to take similar cases in opposite directions. The other problem is that the courts change their minds. In Nevada, we have a fantastic illustration of this in the Shue versus McCarran case. In Shue versus McCarran, Mr. Shue sued the county saying that the regulation limiting development and authorizing air traffic through his airspace was a taking. And the Nevada Supreme Court said, no, that's totally not a taking. When Steve Sisolak made the exact same complaint, the Nevada Supreme Court, looking at the exact same regulation with the exact same limitation, said, oh yeah, that's a taking. That's a problem. Mr. Shue came back to the Nevada Supreme Court, and the Nevada Supreme Court said, oh yes, sorry, that's a taking. We understand that better now. So you have the exact same county, the exact same regulation, the exact same arguments, frankly, and the cases come out in exactly opposite ways. That is frustrating. The other problem is that land use law, where it is governed by statutes and regulations, and acquisitions where they are governed by statutes and regulations, are often hyper precise. And so, you will have, for example, in relocation law, just to give you a random example, because that's what I was working on earlier today, you will have books worth of regulations on exactly how you decide whether or not you have to move an individual hairstylist in an individual hair salon away from that hair salon because the hair salon is being relocated. And so they're hyper precise and exhaustive in nature, but sometimes those provisions haven't actually been construed. That is, a court hasn't told you how you actually apply them. And so then we just kind of rope right back to the previous slide where maybe something is or is not okay. As a result, the law, when it intersects with people, kind of winds up with this. If you come ask a lawyer a question, we'll either tell you it depends, we'll shrug our shoulders, or we'll start yelling at you in paragraphs because how dare you overlook that section 1843 sub C sub 2 sub little I sub J sub 1 sub little triple I says, and then we'll tell you something exceedingly detailed. You come and ask us the very next question and we say, I don't know, what do you think? And the law just be like that sometimes. So what do we do with all of this? Well, the first thing that I think that we should do is just don't assume that your custom is legal. If you've done something the same way for 10, 15, 20 years, seems safe, but it might not be. And it might already not be legal, or it might simply become not legal when the court changes its mind. So don't assume that what you're doing is safe. Number 2, get an in-house audit. If you are working with a public entity and your public entity has the bandwidth and budget for it, go ask your city attorney, your district attorney, your rep to just take a double look and make sure that your attorneys who will be defending you understand what you're doing, and make sure that you understand what the city attorney or district attorney would hope you would be doing instead. Number 3, when you get pushback in the planning process, get in touch with legal sooner rather than later. It is increasingly the case post Koontz that you don't need to have a final, county commissioner approved resolution to have the official action that can get you in trouble. The courts are exceedingly pushing back what what actions by staff, frankly, of public entities will qualify as official action that can cause consequences. Likely, if you get radio silence, you've asked for something or you've made a proposal and the developer just goes silent on you, you might want to raise a red flag that there might be an issue. Traditionally, it had been the case that unless you had a final approved imposition on a developer with an objection from the developer to that specific imposition, that you didn't have a problem. More and more, just as with the pushback coming earlier, radio silence is no longer necessarily a bar to all claims. In particular, in my line of work, inverse condemnation still requires the exhaustion of administrative remedies. That is, landowners have to object officially and on the record before bringing a takings claim against a land use regulation or dedication request. But for pre-condemnation damages or for Koontz-style unconstitutional conditions claims, that exhaustion does not seem to be required. So silence used to be acquiescence. Silence was golden. Now it is not. Now silence is rather terrifying. So if you get ghosted, call a lawyer. So that's what's going on with the legal update that I wanted to talk to you about, to give you kind of a sense of the changing contours of some of the legal underpinnings and legal consequences of land use decisions as they increasingly change the line from actionable public decisions to what seems to have previously been the domain of the planning process. I bring this to your attention for a couple of things. Number one, it's just good to know so that you don't inadvertently commit a public entity to some course of conduct when you are simply noodling around with lines on a map. And also, because I think that it is important to understand that a lot of these concerns are motivated by essential fairness concerns, which is an interesting thing. If we go back a couple, you've got these exhaustive yellow candy heart recitals of just a bajillion lines of small text. But then over on kind of green heartland, the question is, it depends. What is fair? And the courts are increasingly looking at some of these traditional notions of fair play and equity to resolve these cases, which is nice insofar as fairness is a good thing and is a goal and is frankly an ethical and moral mandate, especially when it comes to government regulation of land. But my goodness, it can be really hard to figure out what fairness is when you have to read into the hearts and minds of, one of 14 possible adjudicators. Tough stuff. But I do want to bring to your attention that the courts seem to be in a mode where they are increasingly protective of property rights and are increasingly doing so on traditional notions of simple fair play, as opposed to having a published rule book that public entities in particular can rely on. We are now going to switch gears, and instead of just talking about fairness and going too far and which power is what and updating you on recent developments in these notions, we're going to talk about traditional planning ethics. But before we do so, if anybody has any questions that they'd like to ask, let's take about 5 minutes and see if there are any questions that I can help you all resolve in your own minds first. And if we don't have any, I'll just, start chatting at you again about ethics. Fred, do you see any questions or people raising their hands or looking like they're going to ask anything?
No questions in the chat box, and I don't see anyone raising their hands. So, we can, if anyone wants to jump in with a question, now is a good time. If not, we'll certainly have Q&A time after Mr. Silver is completed with his full presentation.
All right, let us just barge ahead then, as I am wont to do. Ethics. All right, what are ethics? They are moral principles that govern a person's behavior of the conducting of an activity. I like the following definition. Ethics refer to imperatives that are recognized as binding upon a person's conduct in some more immediate and binding sense than law, and yet in some more general and impersonal sense than morals. At least in some definitions, law, morals, and ethics are all part of a general subject that includes all aspects of the concept of obligation. This is from Jeff Hazard's Ethics and the Practice of Law, which was quoted by Black's Law Dictionary, which is a pretty authoritative source in the legal world about what things mean. I like this definition because I think it personalizes why ethics matter and what ethics fundamentally are. They are obligations that we have to each other that we abstract into kind of a formal and impersonal set of duties. But they are based on an obligation to treat one another fairly. This is the magic, I think, behind being able to smoosh our legal concepts of taking and fair play and justice and dovetailing them into ethics, because it is the same essential question of the soul, frankly, for lack of a better word, which is how do we treat each other fairly, and what rules do we impose to vindicate that notion that we should treat people fairly, that we should treat people equally and with equity and justly. Morals are hyper-personal, and you can vindicate them in, well, whatever particular way your moral code allows. Law is not necessarily limited to notions of ethics. There is nothing unethical about driving 56 miles per hour as opposed to 55 miles per hour. We just picked a random number to vindicate the notion that we should all drive, quote, safely so that we don't kill each other. Jaywalking is not a moral failure. It is, again, an abstraction and just a general way to vindicate the notion that we should all be safe out in public. Ethics get us to the heart of some of these things. Now, why do we talk about ethics? Because it is important. Why do we have a slide asking why we talk about ethics? Because the ethics toolkit says we're supposed to in order for us to qualify for CM ethics credits using format 3.1 in lecture format. Ethics, there's no ethical mandate that I have this slide. There's no moral mandate that I have this slide. This slide exists because you have a code that says I have to have this slide. Some codes are prescriptions for actions. All right, let's take another cut at it. Why do we talk about ethics? Because ethics are rarely cut and dry, and discussion can help ferret out best practices and standards to apply to complicated and nuanced circumstances. I need to remind you that this is general discussion. It is not legal advice. I am a lawyer, but I am not your lawyer. And looking at the roster of people, I might be a couple of your lawyers, maybe. A couple of your entities at any rate. But I am not giving you individual legal advice. This is not binding guidance either. I am not giving you an ethics opinion that is binding on the APA. All communications regarding specific situations should occur either in a letter or phone conversation with the APA Executive Director, currently Paul Farmer, FAICP, in his or her capacity as the ethics officer. Because of issues of reliability and confidentiality, email communication is not to be used. I suspect that this block language that I'm supposed to include will change in the next couple of years as email is pretty frankly reliable and secure at this juncture. All right, so what's a code? Well, I like movies, so I have this wonderful illustration. The codes can be like guidelines. Now, in this movie, obviously, the use of guideline was meant to insinuate that they were not binding. But actually, codes are profoundly binding. The reason we say that they are guidelines is because in the American system of law and ethics, we generally do not attempt to exhaustively account for each individual situation. We use a guideline to create prohibitions and mandates that are going to be further interpreted. And thus, a code is thought to include more than the precise written words, but will include the unwritten law, interpretation, common sense understanding, and custom in a particular area. So the words that you see are not the code itself. It is merely a guideline that we use to get to our obligations and our prohibitions. Ethics guidelines and codes and statutes share this in that statutory law is often arranged in codes. California, for example, volumes of law are specified as whatever the subject matter is: code, family code, penal code, code of civil procedure. In Nevada has an interesting note. We call our code the Nevada Revised Statutes. This drives our law librarians nuts because a statute is not a code. A statute is an act of legislature that then gets codified. So we really should have the Nevada Revised Code. Nevertheless, we call it the Nevada Revised Statute. It is arranged in volumes and chapters with individual laws denoted as sections. So you'll see a citation, something like NRS 241.063. This is chapter 241 of the Nevada Revised Statutes as codified at section 0.036. The same basic format works for our ethics codes, and the same basic rules of interpretation apply, which is that we read the words, but then on top of the words, we apply common sense, custom, unwritten precedent, or interpretations to discern what the words mean. And in this way, they are guidelines. All right, you guys have a code. It's fantastic. It's got 26 shouts and thou shalt nots. We're going to focus on just a couple of them because otherwise we would be here all day, and I know everybody would prefer to be furiously refreshing their news feed today to see what in the world is happening. We're going to start with some trends in ethics. Good news, you all are getting more honest and fair. A couple of years ago when I gave this talk, the number one issue in ethics complaints was on matters of honesty and fair dealing. There were 40 complaints. It was the number one problem. So that was bad. Fortunately, the raw numbers have fallen to only 23 complaints, and it's only the number 6th issue. So that is good. Unfortunately, that apparently has come at the expense of quality of practice, which is the new number one complaint. We are going to start by talking about inaccurate information and untruthfulness, which I think is the single number one variable in honest and fair dealing, which is a principle. And I want to talk to you about the legal concept of candor, because I'm going to encourage you to adopt a system of candor in your own conduct when you are trying to vindicate the principle of honest and fair dealing through the code that prohibits inaccurate information and untruthfulness. Candor is more than honesty. It is actually transparency. It is the oath of a witness in a trial, which is not just to not lie, but is to tell the truth, the whole truth, and nothing but the truth. The ethical principles at play here are fairness and honesty. We've got, for example, a hypothetical, which I'm sure has never happened in the past year, where let's imagine you've got a dead spot of land. You've got a dead land use, and it needs to be redeveloped. It truly does. There is a zoning change proposed, and the zoning change will allow for intense uses just based on what the new zone will be. The public explanation for the zoning change, which is like, hey, we want to get rid of this brown field and we want to build, 4 little apartments, buildings on it, and we want to have a little clubhouse for the public to come and recreate. And that is the public relations onslaught. And the public supports the application. The county commission reviews this. They see that there's 20 people saying, yeah, this is great, let's do this. And so they approve the application. And upon approving the application, lo and behold, oh no, this publicly announced, this is what we're going to do, won't work. And the proposed use is taken off of the table and is replaced instead with a significantly more intense use, a more maximalist use that is certainly consistent with the zone change, but is inconsistent with the public statement that was made in community meetings. And the question that I want to pose to you is, does this seem untruthful? Now, I'm going to modify this a little bit and say that nothing that the developer said in this hypothetical was a lie. There were no untruths said, because the proposed use was clearly always just a proposal and an effort. It was never a guarantee. So there was no lie. Nevertheless, does this meet the question of candor? And let's just assume for a minute that the planner involved here and that the developer involved here were always telling the truth, that they truly did want to do the smaller project with the public amenity, and that it truly just didn't pencil at the end for reasons that could not have been known to the developer at that time. Was this still a fair communication? Well, the problem is this. Even assuming that there were no lies, and even without casting aspersions, let's focus for a minute not on what the developer was intending to communicate, but on what the public was likely to perceive. Well, the public is likely to believe that they got duped, that they got sandbagged, and that the developer had a bad motive. And what are the consequences here? Well, there's going to be heavy scrutiny on any future development of that site. You can guarantee that. The neighbors will be riled up. But there are also some additional problems, which is that it will increase distrust in general of the government process and will increase distrust of developers. So what do we do here? If the public becomes convinced that the process is rigged, what benefit is there? And this is why I want you to, if we go back and we look on the code, we look at Rule 1, which prohibits inaccurate information, untruthfulness, I want you to consider whether emphasizing a proposal that may or may not come to pass can, unfortunately, become untruthful communication. Not because there was a positive lie. Again, there are no actual lies told in this hypothetical. It is simply that the hope did not come to pass. But if we focus not on the communication, but on the received understanding, do we have an issue? And what do we do about that? I think that by changing the gloss, the understanding of the rule away from lack of untruthfulness and replace it instead with an affirmative obligation to be candid, to increase transparency, you reduce the risk that you are going to have bad outcomes based on your communications. And when we look at the underlying principles governing these rules, I think that that is where we should be targeting our efforts. So my pitch from me to you, although this is not, as I say, binding guidance or legal opinion, is if you want to be safe and you want to really help protect the profession and you want to really help bolster public confidence in the process, is you should go one step farther than avoiding lies. You should be as transparent as humanly possible. I think if the developer had been candid with the public that, hey, we're going to try X, but if X doesn't work, here's our fallback plan, the public may still have supported the project in this hypothetical. And even if they'd had reduced support, the public would not have felt betrayed. And the public would have more confidence going forward in the profession, the government, and that particular hypothetical, of course, developer. So I would encourage you all to focus on candor where you can. All right. Let's focus on some other issues now that help increase confidence in the planning system. I want to talk to you about private communications. This is Rule 8 and 9. Section B, Rule 8, we shall not, as public officials or employees, engage in private communications with planning process participants if the discussions relate to a matter over which we have authority to make a binding final determination, if such private communications are prohibited. And that's an important thing, by the way, that caveat. If such private communications are prohibited by law or by agency rules, procedures, or custom. The flip side of the coin is we shall not engage in private communications with decision makers in the planning process in any manner prohibited by law or agency rules, procedures, or custom. Rule 8 really gets to your role as an adjudicator in the public planning process. And Rule 9 seems to prohibit surreptitious conversations if you are an applicant or perhaps a public planner who is not in an adjudicatory role, but in an advisory role. So let's talk about a couple of hypotheticals here. You're a public planner. Can you link to people on LinkedIn? Well, how about your elected bosses? Is that okay? What about local real estate developers or a local historic conservation person or a local anti-growth advocate or a smart cities scholar? Are these the sort of communications or private outreach that can cause a problem? And the answer is our favorite green heart from earlier in this presentation, which is it depends. The rules, the guidelines, the code doesn't prohibit all private communications. You can have friends, you can have connections, you can have contact that is outside of the public sphere. But you must make sure, and you have an obligation to ensure, that you are not having those sort of conversations that relate to the planning process that would otherwise violate custom. I think that here, we don't necessarily have so many direct concerns about Rule 8 or 9 when you are just connecting with people, although obviously watch out for your private messages. But I think you need to take it down a step further and look at Principle 2C that underpin the codes, which is that here we really want to be looking for integrity issues. So again, it's a situation where you've got the strict words here, and that is all well and good, but you also want to ensure that you are behaving in a way that has high integrity. And the easiest way to vindicate that is with high transparency. Principle 2C requires that you avoid a conflict of interest or even the appearance of a conflict of interest in accepting assignments. And I think that you are in a situation where, as individual ties become more publicly available, you are increasingly in a situation where you can be scrutinized. And going back to our prior hypothetical concerning maybe less than candid yet technically truthful communications, we need to ask ourselves, what are the point of these connections, and how do these rules actually get to a particular interest? Being a public planner who is connected to people, does that infer that you have some outside influence that can be deployed to private advantage? I think that the answer is no, so long as you are not known for engaging in surreptitious conversation. Let's go on to another hypothetical. As a planner working on a project, you become convinced that the project is actually a bad design. It meets with preliminary approval, and it gets bashed a lot on the Facebooks. You comment negatively on the design. Do you have a problem? Are you meeting your obligations to avoid conflicts of interest and apparent conflicts of interest? Are you meeting your obligations to not engage in secretive communications? And are you meeting your obligations to only have truthful communications? This is trickier. I think that you begin to have problems in rules 8 and 9 and rules 1, frankly, when you engage in this sort of behavior. Let's make it a little spicier. What if you use a fictitious name to make comments contrary to your official position? Well, I think that this is a massive problem. I think that this is clearly unethical behavior. I think it would be a violation of Rule 8 and 9, and I think it would certainly be a violation of Rule 1. If you are hiding your identity, I think you are creating an appearance of conflict of interest. I think you are engaging in secretive communications, and I think that that information that you are discussing is per se untruthful because you are hiding the identity of the speaker. I will tell you all point blank that I stole some of these hypotheticals from a guy named Dwight Merriam, who's another eminent domain planning land use attorney. Interestingly, in the past couple of months, for those of you up here in Northern Nevada, you may have seen news reports of a public official using fictitious names to make comments concerning the official business of that public entity. Not a planning entity, fortunately, for all of us, but these are things that actually do happen out in the real world. So please be cognizant that you don't do that. All right, let's stay on this same hypothetical, which is a planner working on a project. You think it's a bad design. You comment negatively on the design on the Facebook, but now let's say that you are friends, and friends are in quote here because friends is how you designate your connections on Facebook, with a member of the local government body who might be able to see your post. I want you all to take a moment here because I want you to consider, let's go back to Rule 8 real quick, and Rule 9. We shall not engage in private communications with planning process participants if the discussions relate to a matter over which we have authority to make a binding final determination, if the private communication is prohibited by law or by agency rules, procedures, or custom. If you're publishing this commentary publicly, are you engaged in a private communication? What does it mean to engage in a private communication? Is a publicly available post private? And then likewise, Rule 9, not engage in private discussions with decision makers in the planning process. And so Rule 9 is really where we're living with this hypothetical. Have you engaged in a Rule 9 private discussion by making a public comment in an informal setting? Technology is a wonderful thing, but it is creating new opportunities, perhaps, for mischief. I think that these are public communications. So I personally don't think that this is a problem so long as you are using your public identity. I want you to also note that you've got some questions concerning Rule 19 here, which is conceal or failing to disclose an interest. If you are publicly commenting on something without disclosing your connection to the project. But where I do think there might be an issue is influence via improper means, which is Rule 13. When we are looking at all of these rules, I think that they all go to vindicate the core notion that our dealings with other people must be fair and honest. And so, if you initially thought, well, this isn't a problem because it's public, I want you to consider whether Rules 13 or 19 change your opinion by having sort of an informal yet definitive statement concerning a plan or project. How might we be better able to pursue relaying things? Should you do everything with 5 pages of disclaimers, which is what we attorneys do in situations like this? Or should you attempt to avoid the medium as much as possible? Many people for the last 10 years or so had advised lawyers in particular and other professionals bound by ethics and transparency rules to just avoid social media. It was not worth the trouble. I think that social media is unavoidable at this point. I think it is omnipresent. And so I would instead simply caution you to, when you engage in communications, remind yourself that these are essentially publications that you are making on the side of the New York Times or the Reno Gazette Journal or the Sun, I guess. These are not akin to having just informal conversations. So you need to keep in mind the method of your conversations and make sure that you are comporting yourself in a way that will always satisfy Rules 8 and 9, but also 13 and 19. All right, let's get off the internet. Let's go to lunch because that sounds much more fun and it is lunchtime. A couple of hypotheticals to run with you. Through long, hard years of service as a planner, you know everybody because it's Reno, right? Or Fernley even, or, Winnemucca, why not? You have a local landowner who calls you with questions and they invite you to lunch. Can you take that lunch and have that conversation? Well, I don't want to freak you out too much because I want to remind you that the planners are supposed to provide information to the public and members of the public concerning the planning process. So long as you keep it vague and general and about the process, I think you're fine. What if it's a local developer side attorney? I still think you're fine. So long as you keep it light and breezy. What if it's me? Well, you can always take me to lunch. I will always gladly accept lunch, and I will abide by your ethical obligations to avoid Rule 8 and 9 conversations. So I'm pretty safe, usually. What if it's a lobbyist? You might want to avoid lobbyists. Why? Because you've got the appearance issue. If you're meeting with them one-on-one in a group, might it give you an appearance that you are engaging in Rule 8 or 9 issues? And might it go to a situation where you are engaged in the, not necessarily a private communication, but the appearance of a private communication that might call into question your impartiality in your role as a decider if you're a public side planner, or as a fellow participant. The thing I want you to remember is that the rule allows that such private communications are not a problem so long as they don't violate the law or custom. And so I would submit to you that likely up here in Northern Nevada, the answer is going to be a little bit different than it might be in some of your larger jurisdictions, because Northern Nevada has a longstanding custom of being a small market where these sorts of personal relationships are inevitable and frankly are to be encouraged, in keeping with the mandate that planners inform and educate the public on planning process. But I do want to caution you that you need to be very scrupulous in making sure that your communications are above board. Finally, what if it's the mayor who's just taking you to lunch and they employ you in the ordinary course? Do you think that that is a problem? Well, under the rules that we've covered so far, it's not a problem in the slightest, as long as you keep it light. That goes for the communications. But what about Rule 5? Rule 5 says, we shall not, as public officials or employees, accept from anyone other than our public employer any compensation, commission, rebate, or other advantage that may be perceived as related to our public office or employment. If you are exclusively a private side planner, you can just ignore me for the next 10 minutes. But if you're a public side planner, pay attention, folks. All right. We have a prohibition against gifts. And value and relative value isn't important. What we want to avoid is the appearance that there is anything that is going on that is designed to improperly influence planning decisions and, in my line of work, particularly land use decisions. We do have a normative assumption that there's an exception where normal social practices not associated with public duty cause a gift. For example, a holiday card, lunch at a conference where everyone is already there. This is also I like to call the silliness rule. If nobody would seriously question whether the thing that you're doing calls into question your impartiality and fairness, then I think you're fine. The interesting thing about the relative value rule is that we typically say that it focuses on, a slight gift, like a bottle of wine, that can be perceived as improper has to be turned down. I know I go to lunch with some of my public agency colleagues on a regular basis, and they always have to pick up the tab, even though in the ordinary course, I would buy my friend a sandwich on Saturday, and then the next time we go out, it would be their turn to treat. Even a sandwich can be small enough and yet problematic. The funny thing is, it goes in the other direction as well. My favorite, in 2008 at the Las Vegas conference, there was a mayor in a hypothetical that gave their planner attendance at a hockey arena skybox. And the actual advice from that meeting was enjoy the game. Relative value swings both ways. You don't have a safe harbor just because something is small, but you don't also have a problem if the value is large, so long as the thing otherwise complies with the rules. And here, because it is the mayor who ordinarily employs you, you are in the anyone other than public employer exception to Rule 5's prohibition on gifts. So enjoy the game. Go Knights. All right. How do we apply some of these things in our real life, especially on the public side? Well, let's imagine that you're at the grill and you see a city council member and you approach because you want to talk shop. Are you fine? Yeah, I think you're probably fine. You're doing this informally, so I don't know if I'd recommend it, but I don't see a huge problem with it. Now let's imagine that there's 3 city council members having the exact same, very innocent and not at all troubling lunch, and you approach to discuss shop. You should not do that. In scenario 1, your constituent or staff talking to your local government representation. I think it's legally fine. I think you might have some questions depending on the nature of your conversation about whether you're engaged in improper lobbying under Rule 13 or you've got a Rule 8 violation or a Rule 9 violation. But legally, you're fine, and ethically, as long as you keep to the code, you're going to be good. Scenario 2, though, is troubling for a different reason. You are now in something, you're talking to something that looks more like a quorum of the government body. And this is a problem for two reasons. Number one, you might be engaging in impermissible conversation with a quorum of the body, which might be an open meeting law violation. And because that would be an illegal communication, that might then run into a Rule 8 violation, which, as you will remember, prohibits communications, or a Rule 9 violation, depending on your role in the process, that prohibits communications that violate law. Sunshine laws are designed to, consistent with our goals of transparency, keep governmenting out in the public. And Nevada has a very robust open meeting law and sunshine law. When you have multiple members of a governing board sitting together, you might be in a situation where their gathering establishes a quorum and thus invokes a public meeting requirement. I want you to know, though, that the open meeting law not only applies to meetings, which is where a quorum is present to deliberate or take action, but it also applies to situations that are not formally meetings, but for which a meeting was required. Over the past 2 years, I've used the Ira Hansen case as an example, and I'm not going to bore you with the details. I've included it in the materials so that you can read it a little more in depth of what the case was about. But what I want to focus on for today's discussion is that the ultimate outcome and defense in Hansen is, oh my goodness, what just happened? Hey, Fred, are you still there?
That I am. We still
okay,
see the
good.
screen, and looks like you might have kicked out of your presentation.
It dumped the slideshow. Are we back into the slideshow now?
Yep.
Okay, perfect. I apologize for that, folks. C'est la vie. The takeaway was that where you had conduct that should have occurred in an open meeting, but did not occur in an open meeting, you had an open meeting law violation. Now, this is very troubling. I will tell you, by the way, that the aftermath is that the particular ill in the Hansen case, which was litigation decisions being made by an executive director on behalf of a public body, the legislature went to kind of patch this in and fix this. So that's good. But the real ill, the broader ill, is that there was official government action taking place outside of an open meeting. I think that anybody who is in the planning profession needs to familiarize themselves with the open meeting law to make sure that they do not inadvertently address a quorum of a public entity. Because I am, in the aftermath of Hansen, concerned that such communications could give rise to a charge that the public body with a quorum was engaged in deliberation. As framed by the majority, the argument of the dissent, saying that there was no meeting, so the open meeting law didn't apply, ignores the fact that actions by a public body must be taken by the body in an open meeting. And this includes, this is no longer the quote, but this includes deliberation. So where you are having conversations with multiple members of public entities, you need to be cognizant that you are not engaging in a deliberation or not facilitating the public body in engaging in a deliberation, because that would very likely violate the open meeting law, which would then dump you back into Rule 8 and 9. Let's see if I can get there without crashing my computer. Great. That would call into question Rule 8 or 9 about engaging in private discussions with decision makers, because it's not in an open meeting, so it's not on the record, in any manner prohibited by law. because perhaps you are violating the open meeting law. The takeaway here, if you look at rules 1, 8, 9, and 5, and maybe a little nod at 13 and 19, is that our ethics code is designed to increase transparency as much as humanly possible for the goal of ensuring public acceptance and public understanding of these planning procedures in which their neighbors, powerful developers, or the government, which is designed to be for the benefit of all of us, but can sometimes be to the detriment of some of us, is not engaged in anything fishy. Thus, I would recommend that you look at the idea of candor, this idea that our communications need to not simply avoid lies, but also be truthful and transparent, and apply them to the manner in which you are communicating as well. If there's no sunshine shining on you, you should probably think that you're engaged in some sort of private conversation. And if that is the case, I think you need to be scrupulously diligent about avoiding not just improper communications, but also those communications that could give the appearance of impropriety. Because I think that when you look at these ethical obligations, although the rules themselves have all sorts of carve-outs and exceptions and safe harbors, which is good, the underlying notion is that we should comport ourselves in a way that maximizes our ethical and moral obligations towards one another. And in the planning process, that means to engage in decisions that affect other people's property in fair, transparent, and therefore candid manner. All right, folks. I've taken you a little bit past 1 o'clock because there was a lot of information to cram in here. Any questions? And this slide was a lot funnier when I did this presentation as part of Halloween, but you know, we've got other scary things going on at the moment. Stop the share, and here we go. All right, folks.
First of all, I just want to thank you, Steve. You know, for those of you that need to go, no problem. I know that we do have a couple questions, and Stephen, again, has been so gracious to stick around and answer those questions. Before everybody logs off, though, as a reminder, this entire session is worth 1.5 AICP CM credits for both planning law and planning ethics. So if you need your 1.5 credits for either, you can either touch base with me or Mark Oblada, and we'll make sure that you get credit for your attendance in today's session. And as a further reminder, if you need to leave, our next online educational luncheon session will be next Tuesday, November 10th, from 12 to 1 p.m. Again, we'll have Mr. Ken Evans, president of the Urban Chamber of Commerce, joining us, kicking off our new speaker series that will take us into February. Brett Wagner, Brett, you had a question in the text that you wanted to ask. Go ahead.
Yes, thank you. This actually pertains to the first subject when we were discussing takings. Common practice here with our Public Works Department in regard to map submissions, zone change submissions, conditional use permit applications. If they don't have a right-of-way, an offer of dedication that's already been accepted or offered somewhere along the way prior, or you know, a named road, for instance, one of the things they'll always ask for is a condition of an approval, being that that right-of-way is offered as part of that, you know, approval.
Yeah.
Is that, I mean, I had to tune out a little bit and I heard a lot of it, but
am I saying that that's a problem? Yes, I am saying that that's a problem. Is it necessarily going to be a taking? No, not necessarily. The question is whether it complies with Nolan and Dolan. So I'll give you a couple of examples. You've got somebody who's coming in for a lot line adjustment. It's going to get reviewed. It's a gimme. It's going to be approved. And yet you want them to give you a road. And let's just assume that there's no offsites. You just want the right-of-way. What relation does their lot line adjustment have with increasing public use of the roadway system? Well, I don't think there is one. So I think you've got a problem there. A parcel map. They're going to take 18 acres from a single parcel to 4 parcels. Well, now you've got an argument that they're going to intensify all use of the area, right? And so maybe you can get your roadway dedication there. But if you're going to try to get it for free, you might have a problem. That was a case that I litigated on behalf of City of North Las Vegas, actually. And I'll tell you, we made our best arguments for why that wasn't a taking, why that was appropriate police power, land use regulation, and why those dedication requirements were permissible. But we got a lot of pushback on whether we had a proportionality problem, because it was 75 feet. That particular parcel had already dedicated 25 feet. And so we were asking for 50 more feet. And that's a lot of land. That's a lot of acreage. Now, in your hypothetical, you said they had none, no roads. And so if you've got none, I think you're going to be in a safer posture, frankly, because you've got access issues that are going to be factors to consider that will go towards the nexus test, which is you've got no access or no easement for access over your property. You want to develop it. That will necessarily include providing public access. But yeah, a lot of public works departments are sticking with their traditional custom of snapping up whatever the current right-of-way map shows. And I got to tell you, I'm having a hard time saying that that's a good idea, because the 5th and Centennial case, those sorts of dedications being taken gave rise to liability on other parcels. And in the Nolan and Dolan cases, even, you had some real hard times with proportionality in particular on those. And then when you compare it to the Sisolak decision, which if you read it aggressively, you might say that, any of these easements being taken for free starts looking extortionate to our Supreme Court. It's tough. I will tell you that has been the custom for many, many, many years at many, many, many public works and planning departments throughout many cities in the nation. So I'm not shocked to hear you say this. And we don't have a case that says that it's per se unacceptable, especially because in your hypothetical, the developer is coming to you with a proposal. So you've got the procedural posture correct, which is that they're coming to you and you could say yes or no, assuming it's something that you could say no to. But then you're in the proportionality and nexus question, and that's tough. If they're just coming in to map something and now you want 75 feet in exchange for a couple of lines,
And in a lot of cases, there is existing roads there that have been built for many years.
Yeah, and so then the question kind of comes down to this: whose problem are you trying to solve? If you guys want a wider road because you want a wider road, that's a you problem, right? And so traditionally what we've done, and by traditionally I mean like in the 80s and 90s, you would just either condemn if you needed to build right now, you would just go acquire the right of way, or you would wait for them to come in and you would do a dedication. The courts are increasingly focused on this idea of we have to look at each parcel of land by itself and determine what its development adds to the road. And that's all you can get from that. If it's an up zone, sure. I think you're in a much safer position there, because the landowner has to concede that they're going to intensify the parcels imposition on the public system. But if you've already got a road and they're not going to do anything that's going to surcharge or overtax that road, and you just want them to dedicate land because you want the land, you might have a problem.
And I've seen it both ways. Obviously, in the upzoning, that makes sense because
Yeah.
it could be an impact. But I've also seen the same requirements on a downzoning, where it's less intensive zoning. On a residential property, for instance, going from
Multi to single.
yeah,
Yeah. I
have an uneasy feeling about it, and in going through the conference here just a couple of weeks ago, I know that was one of the topics, and that had a lot of flags and questions.
Yeah, so this is my opinion. This is not legal advice, and I am not pretending that what I'm about to say is the law. I want to make those caveats, especially because I know I'm being recorded.
Right.
My cut at it is this. I think that the reflexive dedication requirements for anything, I don't think that complies with Nolan and Dolan. I just don't. If you've got an intense application come through, sure, as applied, you're gonna be fine. But if you're doing it for everything that walks into the door, it seems to me like you're just solving the public's problem, not the problems caused by the proposed development. And I think that is what Nolan and Dolan and Sisolak try to get to, for saying that these easements are probably something that you have to compensate for.
Yeah, I mean, it even went to, in some cases, a door knocking campaign where they go and ask, for that right-of-way dedication. And
yeah, well, you see those ones, and I know that still happens. If the landowner will do it voluntarily, c'est la vie, right? People can give you property, but the cases just aren't going that way. The courts are increasingly suspicious of that, especially because, just as kind of a digression, you're talking about the 1930s, the 1940s, 50s, even the 60s, when we're building out our roadway infrastructure in the first instance. I think the courts were very deferential because roads were good for everyone, including the landowner, right? It benefited everyone, including the person that you had just taken land from. But now that a lot of this infrastructure is built out and mature, and we're just widening and intensifying it, there's really not much benefit in it for the land the landowner who you come and you say, hey, give us 15 feet. What's in it for them? Not much, really. And so unless they're causing a problem that 15 feet is going to solve, and again, it's got to be the problem they're causing that's being solved by the 15 feet, I think you're in a situation where you probably are supposed to compensate them for that 15 feet. And, it is where we are.
yeah, I think I'll be referring that one to the DA's office. Take a look at it.
Yeah, no, and that's why in my slideshow, I don't know if you were here for this one, I truly recommend 3 things. Number 1, don't assume that your custom is legal. Number 2, get lawyers involved early. And number 3, have a full-blown audit done. I have to confess, I don't know which county you work for, and that's okay. I don't need to know, and I probably don't want to know, to be real honest with you, based on your hypothetical. So I'm just going to earmuffs, and I won't look you up afterwards. You should get the city attorney or the city or the district attorney's deputies involved to audit, just so the county can understand what liability it might be facing. Because I have had, in my experience, public works people tend to stay there for 20, 30 years, and the civil DA or civil city attorney has been there for 4. And so the attorney has no institutional knowledge of what you're doing. And so they haven't made their own risk assessment analysis that, hey, this policy works 90% of the time and we'll just deal with the 10% when they come. Or this policy works 99% of the time, so screw it, right? Let them sue if they want to. Or oh my God, this works 50% of the time, and that's a real problem. 50% compliance is bad. They just lack the institutional knowledge. So there needs to be kind of that mutual educational component. And at the end of the day, with all law claims, it comes down to, you know, we have a duty to protect property rights for sure. But when we're advising our public clients, there's also just, you have to make a business decision, which is understanding these risks. What do you want to do? That's why I have that whole section on the problem of laws, that the courts change their minds sometimes. And so as long as you know what the lawyer thinks and the lawyer knows what you're doing, you can sit down and have a comfortable meeting of the minds where you decide what the policy is going to be. But in my experience, unfortunately, the two don't intersect. And so you wind up with suits where the city attorney or the district attorney is wholly unprepared to defend the conduct of public works. And likewise, public works is shocked because no one has ever come to tell them that what they're doing hasn't worked for 15 years. And so get the lawyers involved, get an audit done. I know times are tough. I know it's hard to get those resources deployed, but when times get tough, that's when landowner attorneys looking for their 33% start looking around for claims to bring. So go get you an audit, my friend.
Thank you very much.
My pleasure.
Any other questions from those that are left? All right, well, we'll call that done for now. So again, thank you, Stephen, for doing this for us. You know, the chapter, myself personally, you know, really thank you for everything you have done for us over the years, and certainly appreciate today's presentation. So for the rest of you, have a wonderful rest of your week, and as usual, stay safe, stay healthy, and get ready for the snow coming to northern Nevada this weekend. Have a great rest of your week.